Affirmative action in higher education is constitutional. In a 4-3 ruling handed down Thursday morning, a divided Supreme Court upheld racial preferences in university admissions. Welcome to your Thursday lunch break, everyone. I'm Tanya Rivero. This comes as a defeat to a years-long conservative drive to roll back affirmative action in higher education. And joining us now to discuss the Supreme Court's decision is WSJ Law Deputy Bureau Chief Ashby Jones. Welcome, Ashby. Thanks so much for being with us.
You bet.
Tell us, what were the highlights of the court's decision?
Well, the highlight was really that Justice Kennedy, who wrote the majority opinion, basically blessed the Texas approach. And the Texas approach is a little bit complicated, but basically the way that UT Austin does its admissions for undergraduates, it says if you go to a Texas public high school and you finish in the top 10% of your class, you're guaranteed admissions. That fills out about 75% of the class. The other 25% of the class is evaluated on kind of a complicated system, test scores and the like, and race can be used as one component in evaluating that other 25% of the class.
Right.
And Justice Kennedy basically said, we're not blessing all affirmative action here, but we do think that this one is sort of narrow enough and focused enough, and Texas has explained why it's doing it well enough that we're going to say okay to it.
And of course, they were focusing on the University of Texas because that is the university against which Abigail Fisher brought her complaint, correct? In 2008, is that when this originated?
That's right. This goes back to 2008. Abigail Fisher did not finish in the top 10%, so she was not guaranteed admission. So she was in that other category. She was not admitted, and she sued, claiming that she was discriminated against.
Right. Okay. So now we know that Justice Elena Kagan recused herself from this. Do we know why?
She was this case has been going on for so long that before she joined the court, she was working as the Solicitor General in the Obama administration, and she actually she worked on the case on behalf of the Obama administration, which was supporting Texas and the UT Austin. So
Right.
she had taken a position, so she couldn't rule on it.
So we kind of know where she would have ruled, and of course there was no vote from the late Justice Scalia, and we sort of know where he would have ruled, so the two of them canceled themselves out, it would seem, the vote anyway.
Essentially, yeah.
Essentially.
Yeah.
But there was a scathing dissent from Justice Alito, a 50-page dissent that he read from the bench. Is that correct?
Yeah, this is unusual for a justice to read a dissent from the bench. It's sort of a signpost that a justice is really unhappy with the way the majority has ruled. And his main point, I mean, he makes a lot of points in there, but his main point is, look, we have a Constitution that guarantees equal protection of the law, and it doesn't say anything about being able to discriminate on the basis of race. And he sort of, as a lot of people have over the years, flipped it on its head and said, look, affirmative action is making discrimination and making determinations based on race. It's favoring one race over others, and that just shouldn't be allowed under our Constitution.
And of course, was it Justice Kennedy that said that's why we have to keep revisiting this, that this is ideally something that will not be in place forever?
That's right, and that goes back to a comment that Justice O'Connor made in a 2003 case. She said, look, affirmative action is meant to be a temporary sort of fix to a problem, a longstanding historical problem. And she basically said we should be looking at a 25-year sort of range for this, that if we look forward from 25 years from when that opinion came out, we should think about sunsetting affirmative action at that point.
Right.
So,
because this is the fourth time since the 70s that the Supreme Court has upheld affirmative action.
That's right. And they keep sort of getting these cases
Right.
that, and they keep saying, well, we're not going to make a very broad, sweeping ruling on this. We're going to look specifically at the details of this individual case, whether it's from the University of Michigan Law School or University of Texas
Right.
or elsewhere. And they did the same thing here. They said, this is not a broad blessing of all affirmative action.
University of Texas.
This is about this one very specific plan, which is different from a lot of other plans.
Worth noting, though, that almost the entire higher educational, institutions in America came out in support of the University of Texas.
They did, because a lot of schools do something similar,
Right.
if not, identical to what Texas did.
Absolutely. Ashby Jones, thank you so much for that.